Good day and salam sejahtera. I bid to Madam Ani Munira and my name is Chee Kiung, metric number 244558. Today, I would like to present my case review on the case of Syed Ismail versus PP 1967. However, before I start my presentation, I would like to give you a brief outlook to the skeleton of my presentations today. Okay, so first of all, we'll go through the details of the case, then move on to the issue of the case, then the help or judgment of the court, and then lastly, reflections or sort of an analysis that I made for this case review. Before I jump into the details of the case, let me give you some important details of the case for you to have a better understanding throughout my presentation. So, this is an appeal case for the corruption offense. However, for the purpose of assignment, we'll be focusing on the character evidence in light of Section 52 until 55 of the Evidence Act 1950. Now, this is the list of the accused in the early stage and there are 3 of them. However, we'll be focusing on Syed Ismail, which is the appellant of the case and also a district officer of Ulu Langat. While this is Hashim bin Talib, the brother-in-law of the appellant, and Raja Shamsusa, the penghulu of Mukim Ulu Langat. However, Raja later then turned into the prosecution witness, giving testimony against both of them. Not to forget our public prosecutor Ajaib Singh and Mr. Chee as the financial clerk of district officer also acting as one of the prosecution witness. Okay, now moving on to the details of the case. Brief facts of the case. Okay, so normally a government project need to open a tender and call for contractor to bid for it. However, since the appellant acting as the district officer of Ulu Langat having the discretion to issue in-depth manor works without any tender, he actually appointed Hashim as the contractor for the concerned project despite that he is of no experience. Next, an indent was then issued by Mr. Chee under the authorizations of the appellant, but there was actually no file being opened due to its only an oral request as per Mr. Chee. And 1 week later, the indent was being brought back to the appellant, stating that the concerned project is duly completed and was even certified by Raja acting as the penghulu. However, in reality, there was no such project and the payment was actually being made by the appellant to the Hashim of 600 ringgit. Okay, this is the arguments by defense. From all of this, we can see that the appellant trying to prove that he is of no idea for this corruption. And it is actually Hashim or Raja the one behind the corruption. For instance, he stated that he requested Raja to inspect the work of Hashim and Hashim actually assured to him that the project is completed without any comment. While this, the argument of prosecution who mainly rely on the testimony given by Raja, who is also the accused, he actually contended that he only signed such indent as per requested by the appellant and under the impression that it was in respect of the continuations of work done for the previous project. Okay, moving on to the issue of the case. As I mentioned previously, since this assignment is all about character evidence, therefore, we will focus on the issue whether the learned president in assessing the credibility of Raja and the appellant had failed to take into consideration of the previous good character of the appellant as opposed to that of Raja as a witness. Next, the health or judgment of the case. Of the case, the court decided to dismiss his appeal due to the inability of the appellant to cast a reasonable doubt to the prosecution case and also there was no positive proof as to the excellence of the appellant character. So coming back to the issue of character evidence, the court considered the propositions argued by the appellant counsel stating that the learned president had failed to take into considerations of the credibility of the witness Raja by comparing the previous good character of the appellant as opposed to that of the Raja. However, the court is of opinion that in this instant case, There was no positive proof as to the excellence of the appellant character, as he only stated his educational background and administrative experience. The court also highlighted the judgment in the case of Emperor Khurshid Hussain, where the learned judge is of opinion that there was no complaint prior to such charge is not equivalent to his having an excellent character, and it is not impossible that he was caught in his first attempt at corruptions. Thus, by merely stating that there was no complaint has been lodged against the appellant was only a negative averment at best, and definitely not enough to raise a reasonable doubt as to his guilt or to the truth of the prosecution case. Moving on to the final part of my presentation, which is the reflection or analysis. First of all, I would like to draw attention to the definition of the term character in Evidence Act 1950, which is the explanation under Section 55, which includes both reputation and dispositions of one. Therefore, it can be inferred that character evidence is a means of using the reputation and disposition of one in the court to prove the probability of him committing a cause or an offense. And, not to forget, character evidence also plays a prominent role, as it is the duty of the court to have regard to the accused's character before imposing the sentence in pursuant to the Section 173A and 294 of Criminal Procedure Code. From here, we can see that the character evidence can be classified into two categories, namely good character and bad character. And also, the applicability of both types are different between criminal and civil cases. Due to the nature of this instant case, it shall be highlighted that bad character of an accused is not relevant, as Section 54 Sub 2 of Evidence Act 1950 had provided a shield for such issue. This is in line with the grounds of public policy and fairness, as it would surprise and prejudice the parties by judging him of his previous conduct, which they could not possibly come to court prepared to defend. Howsoever, there was an exception provided under Section 54 of the Act, stating that admission of such evidence will be allowed when the character of the accused was in question. On the other hand, good character is relevant in the criminal cases. This can be clearly seen in the present case judgment, where the court clearly stated that when an accused in a bribery case is managed to prove of good character, and the court will have to take into account of the improbability of such person would not likely to commit such offense. However, it was concluded that for one to prove that he is of good character, by merely adducing that there was no previous complaint made against him is totally insufficient for the court. Lastly, the law for character evidence under the Evidence Act 1950 is much more progressive compared to the one during the time of the instant case. This is because Section 54 Sub 2 Sub C of Evidence Act 1950 clearly stated that evidence of previous bad character can be admitted if the accused elected to give evidence against the co-accused. Therefore, in this instant case, by applying such provision, the evidence adduced by Raja, an accused himself and also acting as one of the main prosecution witness, its probative value will be reduced greatly when the defense are able to prove him of bad character. From this, it will increase the possibility of acquittal for the appellant, as the defense is able to cast more doubts in the prosecution case. All in all, despite that there are some failures of the counsel to impeach the credibility of the witness, I will still stand firmly with the judgment of this instant case. This is because the facts adduced by the appellant himself are full of suspicions and is further amplified with the Bira's relationship between him and Hisham. Not only that, despite that there are some opinions like the one in the case of Bhagwan Swarup versus State of Maharashtra, stating that the character evidence is a very weak type of evidence. I personally do not agree with it because being a witness in a court or an accused who opts to give statement during the trial, his character or disposition will have a direct link to the credibility and the admissibility of it as an evidence. For instance, witness having bad character The statement made by him naturally will be of law improbative value. Thus, the importance and weight of character evidence shall never be underestimated nor overlooked by the parties. That's all for my presentation, and thank you very much for listening.